Hello friends, welcome back to series of lecture, and this is the 59th lecture of this series of CRPC. In today's lecture we would start from section 195 of the CRPC. No court shall take cognizance of any offence punishable under section 172 to 188 of IPC of any abatement or attempt to commit such offence or any criminal conspiracy to commit such offence, except on the complaint in writing of the public servant concerned or of some other public servant to whom he is administratively subordinate. Basically, they are referring to section 172 to section 188 और section 200 के समय हमने ये sections देखे थे. So these sections, if you remember, are related to public servants. 172 section 188 of IPC. And under these cases, they are saying, so either these cases or abatement of these cases या फिर attempt of such offences या फिर criminal conspiracy of such offences. So abatement, attempt or criminal conspiracy of any of such offence, except on the complaint in writing of the public servant concerned or of some other public servant to whom he is administratively subordinate. तो ये पहले हम सेक्शन 200 में देख चुके हैं दैट कि इन केसेस में एफआईआर नहीं होगा, इन केसेस में इंफॉर्मेशन पे कॉग्निजेंस नहीं होगा. इन दीज केसेस द कॉग्निजेंस विल बी डन ओनली ऑन द कंप्लेंट इन राइटिंग. अब ये कंप्लेंट कौन फाइल करेगा? दैट पर्टिकुलर पब्लिक सर्वेंट और हिज सुपीरियर पब्लिक सर्वेंट. इफ यू आर ए पब्लिक servant, a police inspector, then you could file a complaint, or your superior officer, DSP, SP, he could file the complaint. Clause B. Of any offence punishable under any of the following sections of the IPC, namely section 193 to 196, 199, 200, 205 to 211 and 228. So all these sections related to the court proceedings of the IPC. So these are the sections of IPC which are related to the court proceedings. When such offence is alleged to have been committed in or in relation to any proceedings in any court proceedings, any proceedings in any court. और अब इसके अलावा और भी sections हैं of any offence described in section 463, 471, 475, 476. तो ये सेक्शन फॉर्जरी वगैरह से रिलेटेड है. कोर्ट में फॉर्ज डॉक्यूमेंट वगैरह प्रोड्यूस करना कम्स अंडर दी सेक्शन. सो कोर्ट में डॉक्यूमेंट्स वगैरह फॉर्ज करके प्रोड्यूस करना और एविडेंस के तौर पर उसको यूज करना. सो दीज सेक्शंस वुड रिलेट टू दैट प्रोसीजर. So these all sections are related to also to the court proceedings of IPC. IPC के ये सारे सेक्शन और court proceedings से relate होते हैं. So check all these sections into IPC and read once. So ये जितने भी sections हैं IPC में इस तरीके के, या 200 की लाइन में हो 193 से 200 की लाइन में 228 तक, या फिर 463 की लाइन में, all these sections are related to court proceedings. And if you committed any of these offences in the court proceedings, so if anyone commit these offences in the court proceedings which falls under these sections, then again only a complaint can be filed, and that to be filed by particular court, that particular court where the wrong was committed. अब इसमें और भी लिख रहे हैं of any criminal conspiracy to commit or attempt to commit or abatement of any offence specified in subclause 1 or subclause 2 except on the complaint. अब यहाँ पे कैसे फाइल होगा ये बता रहे हैं. Except on the complaint in writing of that court or by such officer of the court as that court may authorize in writing in this behalf or some other court to which that court is subordinate. मीन्स जिस कोर्ट में आपने ये ऑफेंस किया है, मीन्स प्रोसीडिंग्स, जैसे फॉल्स एविडेंस सेक्शन 193. सपोज आई एम ए कोर्ट एंड देयर इज ट्रायल गोइंग ऑन एंड यू अपीयर एंड यू गेव ए फॉल्स एविडेंस in this court, in my court. So I will not take proceedings of false evidence against you. I will become a complainant. This court will become a complainant, and a complaint will be filed before a judicial magistrate. And that judicial magistrate, upon my complaint, will take up the cognizance and go on with the proceedings. So the court in which you gave false evidence, that court will not initiate the false evidence का proceedings. But that court, या तो मैं खुद फाइल कर दूंगा अगर मैं कोर्ट हूँ, या फिर और द सुपीरियर कोर्ट, या तो मैं खुद रिटन कंप्लेंट फाइल करूंगा या मेरा कोई सुपीरियर कोर्ट है वो फाइल कर देगा रिटन कंप्लेंट बिफोर अ मजिस्ट्रेट. Means if it is a offense related to the public servant, then the public servant will file a complaint, and if it is a offense related to court, then the court will file a complaint. FIR और information पे cognizance नहीं होगा. FIR पे तो cognizance मिलता भी नहीं है. FIR पे तो cognizance मिलता भी नहीं है. पुलिस रिपोर्ट पे और इंफॉर्मेशन पे cognizance नहीं होगा और FIR लॉन्च नहीं किया जाएगा. नेक्स्ट क्लॉज. Where a complaint has been made by a public servant under clause A of subsection 1, any authority to which he is administratively subordinate may order the withdrawal of the complaint and send a copy of such order to the court, and upon its receipt by the court, no further proceedings shall be taken on the complaint. Shall be taken on the complaint means court is bound to allow the withdrawal, provided that no such withdrawal shall be ordered if the trial in the courts of the first instance has been concluded. अब ट्रायल इन द ट्रायल कोर्ट खत्म हो चुका है एंड द मैटर इज पेंडिंग इन टू द अपील, और अब सुपीरियर ऑफिसर कहता है कि मैं विड्रॉल करना चाहता हूँ, देन ही कुड नॉट डू दैट, ही वुड नॉट अलाउड. एग्जाम्पल से समझ लेते हैं. मान लो किसी एक व्यक्ति ने फॉल्स FIR फाइल किया पुलिस स्टेशन में. दैट पुलिस ऑफिसर लेटर ऑन files a complaint under section 182. Later on that SHO files a complaint under section 182 of the IPC. क्योंकि false FIR पर 182 लगता है, so that police officer SHO files the complaint under section 182 of IPC against that informant for the false FIR. The proceedings started in the magistrate court. The DCP to whom that SHO is subordinate. The DCP writes a letter to the magistrate for the withdrawal. The DCP to whom the SHO is subordinate writes a withdrawal letter to the withdrawal letter and send it to the judicial magistrate जहाँ पर proceedings चल रही है. Then the judicial magistrate thereupon will be bound to allow the withdrawal. SHO ने बेशक 182 में कंप्लेंट दिया है, अगर उसका सुपीरियर ऑफिसर जिसके अंडर वो है, अगर सुपीरियर ऑफिसर चाहे तो उस कंप्लेंट को विड्रॉ कर सकता है. लेकिन मान लो जुडिशियल मजिस्ट्रेट के कोर्ट में ट्रायल हो चुका है और जजमेंट पास हो चुका है और अब मैटर पेंडिंग है अपील में कोर्ट ऑफ सेशन में, और अब DCP साहब लिखते हैं दैट आई वांट टू विड्रॉ द मैटर, देन इट वुड नॉट अलाउ. So if you want to withdraw, you would be allowed to withdraw only while the proceedings are going on in the trial court. So other clauses of the 195 are easy and do it yourself. Now let's see section 196 of CRPC. No court shall take cognizance of any offence punishable under chapter 6 or under section 153A, section 295A or subsection 1 of section 505 of Indian IPC, or a criminal conspiracy to commit such offence or any such abatement as it described in section 108A of the IPC, except with the previous sanction of the central government or of the state government. अब यहाँ पे in this section they are talking about the criminal conspiracy. So in some of the cases of criminal conspiracy, कुछ cases में criminal conspiracy पे ये नहीं कह रहे कि FIR होगा, complaint होगा, उस चीज पर restriction नहीं लगा रही. They are putting some restriction. So they are putting only one restriction, that cognizance will be taken only when with the permission of the central government or the state government. They are not saying that you cannot file FIR or you cannot take cognizance on information. वैसा कोई restriction नहीं लगा रहे. तो ये नहीं कह रहे हैं कि तुम FIR फाइल नहीं कर सकते या कंप्लेंट नहीं फाइल कर सकते, ऐसा कोई रेस्ट्रिक्शन नहीं लगा रहे हैं वो। द ओनली थिंग दे आर सेइंग, द ओनली रिस्ट्रिक्शन इज दैट cognizance can be taken only by the sanction of the state government or central government. सो ये दो सेक्शन दे रखे हैं चैप्टर 6 में 153, ये ब्रीच ऑफ हार्मनी वगैरह के सेक्शंस हैं, ये IPC में चेक कर लेना। एनी ऑफेंस पनिशेबल अंडर चैप्टर 6 और अंडर सेक्शन 153A, सेक्शन 295A और सबसेक्शन 1 ऑफ 505 ऑफ IPC, or a criminal conspiracy to commit such offense or any such abatement as is described in 108 of the IPC, except with the previous sanction of the central government of the state government or of the state government. No court shall take cognizance of any offense punishable under section 153B or section 2 of or subsection 3 of section 505 of the Indian IPC or a criminal conspiracy to commit such offense. अब यहाँ पे ये क्रिमिनल कॉन्स्पिरेसी की बात कर रहे हैं, पहले वाले में क्रिमिनल कॉन्स्पिरेसी भी था और अवेटमेंट भी था, एक्सेप्ट विद द प्रीवियस सैंक्शन ऑफ द सेंट्रल गवर्नमेंट और द स्टेट गवर्नमेंट और ऑफ द डिस्ट्रिक्ट मजिस्ट्रेट। अब यहाँ पे डिस्ट्रिक्ट मजिस्ट्रेट आया है, बल्कि पहले वाले में ओनली द स्टेट गवर्नमेंट और सेंट्रल गवर्नमेंट। अब ये जो नेक्स्ट क्लाउज, सेकंड क्लाउज, दैट इज इम्पोर्टेंट फॉर IPC। नो कोर्ट शैल टेक कॉग्निजेंस, नो कोर्ट शैल टेक कॉग्निजेंस ऑफ द ऑफेंस of any criminal conspiracy punishable under section 120B of the IPC other than a criminal conspiracy to commit an offense punishable with death, imprisonment for life or rigorous imprisonment for a term of 2 years or upwards, unless the state government or the district magistrate has consented in writing to the initiation of the proceedings। अब ये ज़्यादा समझ में आपको जब आएगा जब अगर आपने क्रिमिनल कॉन्स्पिरेसी IPC में पढ़ा होगा। देखो, रिमेम्बर इन criminal conspiracy there are 3 kinds of conspiracy. One is the conspiracy to commit the civil wrong। अगर आप सिविल रॉन्ग करने का कॉन्स्पिरेसी करते हो तो वो भी 120B में आएगा। और conspiracy to commit something which is prohibited by law, और conspiracy to commit something which is prohibited by law, this is the second type of conspiracy that would come under conspiracy। और the conspiracy to commit an offense, offense में भी if the offense is punishable with less than 2 years or it can be punishable by greater than or equal to 2 years or punishable with death or it may be punishable with life imprisonment। so जब criminal conspiracy का देखोगे आप IPC में, then 120 का clause 2 है, that would be related to this 2, इससे this all 3 2 years वाले तक। एंड जो 120B का क्लॉज 1 है, दैट इज रिलेटेड टू दिस। सो कोई भी यदि आपने कॉन्स्पिरेसी किया किसी ऐसे ऑफेंस के लिए जो कि 2 साल या उससे ज़्यादा का पनिशेबल है ऑफेंस है, डेथ या लाइफ इम्प्रिजमेंट से पनिशेबल है, इन दोज केसेस दे आर सेइंग दैट देयर you will be punishable as you are a better of that offense। और ये जो दूसरे वाले में where you are conspired for doing civil wrong or you are conspired to do a prohibited by law or offense less than 2 years to commit an offense which is punishable less than 2 years, in this they are saying the maximum punishment is 6 months in these 3। so for this 3 अभी हमें इससे कोई मतलब नहीं है, we are not concerned about this। सो हमको इससे कंसर्न नहीं है कि भाई कितना पनिशमेंट होगा क्या नहीं होगा इसमें, इन दोनों में। हमारा कंसर्न हियर इज दिस, वी आर कंसर्न विद दिस दैट दे आर क्लियरली सेइंग दैट इफ यू वांट टू प्रोसिक्यूट समवन एंड द कोर्ट वांट टू टेक द कॉग्निजेंस, इफ द मजिस्ट्रेट वांट्स टू टेक कॉग्निजेंस फॉर दिस वन एंड दिस वन। अब ये क्लियरली नहीं लिखा हुआ है, इसमें लिखा हुआ है कि 2 साल या उससे ज़्यादा पनिशेबल या डेथ या लाइफ इम्प्रिजमेंट से पनिशेबल कोई ऑफेंस हो तो उधर कंसेंट लेने की ज़रूरत नहीं है। बट फॉर अदर काइंड्स ऑफ कॉन्स्पिरेसी, अब अदर काइंड में क्या बचता है, अब ये तो बता दिया स्पेसिफिकली, अदर काइंड में फिर ये तीनों ही तो बचे। सो अदर काइंड्स ऑफ कॉन्स्पिरेसी अंडर 120B दे आर सेइंग that the written consent of the state government or central government or district magistrate is required. अब अगर दोबारा देखते हैं क्लॉज 2 को हम, नो कोर्ट शैल टेक कॉग्निजेंस, नो कोर्ट शैल टेक कॉग्निजेंस ऑफ द ऑफेंस ऑफ एनी क्रिमिनल कॉन्स्पिरेसी punishable under section 120B of the IPC other than इनको छोड़कर other than a criminal conspiracy to commit an offense punishable with death, imprisonment of for life or rigorous imprisonment for a term of 2 years or upward, इनको छोड़कर. So what is the situation after leaving this one, इसको छोड़कर 2 years से upward, death or life imprisonment. No court shall take cognizance of offence any criminal conspiracy punishable under 120B of the IPC other than a criminal conspiracy to commit an offence punishable with death, imprisonment for life or rigorous imprisonment or for a term of 2 years or upward, or rigorous imprisonment for a term of 2 years or upward, unless in cases को छोड़कर no court shall take cognizance of the offence of criminal conspiracy punishable under 120B of IPC. अब इनको छोड़ देंगे तो बाकी का क्या बचेगा हमारे पास, यही 3 बचेंगे, ये वाली सिचुएशन बचेंगी ये तीनों. So no court shall take cognizance of offence any criminal conspiracy punishable under 120B of IPC except this, unless the state government or the district magistrate has consented in writing to the initiation of the proceedings. Provided that where the criminal conspiracy is one to which the provisions of section 195 apply, no such consent shall be necessary. So तो इन सिचुएशंस में जो 3 सिचुएशंस रह गई हैं, कॉग्निजेंस पे नहीं ले सकता unless the state government or the district magistrate has consented in writing to the initiation of the proceedings. So in these cases, no direct cognizance can be taken unless the state government or district judge consented in writing. In this, direct cognizance can be taken in this situation. So that's it for section 196, or here by mistake somewhere I told central government, so correct it. It is a state government or district judge. Now let's move to section 198 of CRPC. No court shall take cognizance of an offence punishable under chapter 20 of IPC. Chapter 20 basically is adultery, bigamy, that is marriage related offences. Chapter 20 of the IPC, except upon a complaint made by some person aggrieved by the offence. So main restriction क्या है, जो marriage related offences हैं, bigamy है, adultery तो अब रहा नहीं खैर, and other offences, उसमें FIR लॉज नहीं होगा, इन्फॉर्मेशन पे कॉग्निजेंस नहीं होगा, जैसे कि डिफेमेशन में था, that is only upon a complaint. Provided that where such person is under the age of 18 years or is an idiot or lunatic or is from sickness or infirmity unable to make complaint, or is woman who according to the local customs and manners ought not to be compelled to appear in public, some other person may with the leave of the court make a complaint or on his or her behalf. So it is same as defamation like case. Where such person is the husband means complainant here. Where such person complainant is husband and he is serving any of the armed forces of the union under the condition which certified by his commanding officer as precluding him from obtaining leave of absence to enable him to make a complaint in person, some other person authorized by the husband in accordance with the provisions of subsection 4 may make a complaint on his behalf. तो ये बेसिकली आर्म फोर्सेस की बात कर रहा है. सपोज एक व्यक्ति किसी आर्म फोर्सेस में काम कर रहा है एंड हिज वाइफ इज अवे फ्रॉम हिम एंड हिज वाइफ इज इनटू बाइगमस मैरिज, अडल्ट्री तो अब रहा नहीं ऑफेंस, एंड दिस मैन हैज टू फाइल अ कंप्लेंट अगेंस्ट हिज वाइफ फॉर बाइगमी एंड इज नॉट गेटिंग लीव, उसको छुट्टी नहीं मिल पा रही है. उसका कमांडिंग ऑफिसर उसने सर्टिफिकेट दे दिया है दैट ही कुड नॉट बी लीव ऑन लीव टू फाइल दैट कंप्लेंट एटसेट्रा. देन व्हाट, देन इन दैट केस किसी और व्यक्ति को जो कि उसको रिप्रेजेंट करेगा, ऑफिसर को, हस्बैंड को, ही कैन फाइल द केस. Some other person authorized by the husband in accordance with the provisions of subsection 4 may make a complaint on his behalf. So, see again, no court shall take cognizance of an offence punishable under chapter 20 of the IPC, that is marriage related offences. That is basically from section 493 up to 498, not include a 498 है नहीं आएगा, that is from 493 to 498. जैसे कि बायगमी है, all that, adultery अब रहा नहीं है, these offense related to marriage related offenses. Regarding that, they are saying that the aggrieved person can file a complaint. So in these cases, FIR will not be there. In these cases, the cognizance on information will not be there. The cognizance will only be upon complaint. So no court shall take cognizance of an offence punishable under chapter 20 of IPC except upon a complaint made by some person aggrieved by the offence. Of this proviso include the exception where complaint is made by some other person, where such person is under the age of 18 or any idiot or lunatic or some sick or infirmity unable to make a complaint, or is a woman who according to the local custom and manners ought not to be compelled to appear in public. Some other person may, with the permission of court, make a complaint on his or her behalf. And B, we had already seen that if a person is working in the armed forces and he had not granted only a leave for filing the case against her wife or husband, officer एक woman भी तो हो सकती है, and the commandant officers provided him or her a certificate that he or she would not granted leave, then in that case any other person representing him or her can file the complaint with the permission of court. Now clause C, where the person aggrieved by an offence punishable under section 494 or section 495, that is bigamy, where the person aggrieved by an offence punishable under bigamy 494 495 of IPC is the wife. So here they are talking only about the wife को privilege दे रहे हैं, husband को नहीं. If the wife complaint may be made on her behalf by the father, mother, brother, sister, son or daughter, or by her father's or mother's or brother or sister, or with the leave of the court by any other person related to her by blood, marriage or adoption. मतलब वाइफ अगर अपने हस्बैंड के खिलाफ बायगमी का केस करना चाह रही है, मीन्स वाइफ वांट टू इनिशिएट द प्रोसीडिंग्स अगेंस्ट हर हस्बैंड फॉर बायगमी, देन ऑन हर बिहाफ रिलेटिव्स कैन बी अलाउड टू फाइल द कंप्लेंट. लेकिन अगर हस्बैंड को वाइफ के खिलाफ करना है तो मान लो कोई एच मैरिड टू डब्लू और डब्लू ने H1 से शादी कर ली और H wants to file complaint against W, means wife. Can the relatives of H, मतलब हस्बैंड के पहला हस्बैंड है उसके रिलेटिव्स को फाइल कर सकते हैं on his behalf? The answer is no. But if it was W, then her relatives can. Suppose in other example, H marries W. Now H marries to W1, and suppose wants to file case against H for the bigamy, then she can either file herself or through a relatives etc. So कभी भी ऐसा कोई provision आए, then it would not be look at biased. Just the privilege is given to a particular sect. So this provision also now not biased as per Article 14 and read with it Article 15 clause 3 of the Indian Constitution. There everything is justified. Any special law for the woman is justified under Article 14 read with Article 15 clause 3 of the Indian Constitution. Because 15 clause 3 clearly कहता है nothing in this article shall prevent the state from making any special provisions for women and children. It may appear to be biased, but it is not. For the purpose of subsection 1, no person other than the husband of the woman shall be deemed to be aggrieved by any offence punishable under section 497 or 498 of the said code, that is adultery. Now suppose H is married to W and someone A is with the knowledge or reason to believe that W is married. A gets into the sexual act with W. Who would be the victim here? It is W or H? It is H, husband. अब मान लो A भी married है W1 से. Here W1 also aggrieved. Why? Because and W has sexual act with her husband A. W1 का तो husband है. So can W1 file the adultery का case against W? The answer is no. IPC में हमने देखा था वो section. Even the W could not be liable for the abatement of the adultery. उस केस में W1 के पास क्या रेमेडी रहेगा? She can go for divorce. But now the present law is after the Supreme Court judgment कि adultery is no more an offense. So here for both husband and wife, इधर जो हम बात कर रहे थे H और W, A और W1, here H के पास भी कोई रेमेडी नहीं है अब today's situation, ना ही means all of four is not having any of the remedy in criminal proceedings, but they have remedy in the civil. They can get the divorce, provided that in the absence of husband, some person who had care of the woman on his behalf at the time when such offense was committed may, with the leave of the court, make a complaint on his behalf. But now for the present situation, this clause is useless. बट ये प्रोवाइजो उससे रिलेट करेगा अगर कोई आर्म फोर्सेस में और ही लेफ्ट हिज वाइफ विद हर फादर. सो हियर इन दिस केस बाहर काम कर रहा है तो अपने माता पिता घर में वाइफ को रख रखा है. देन हु इज द गार्जियन ऑफ द वाइफ? द गार्जियन इज द फादर इन लॉ ऑफ द वुमेन. सो इन दिस सिचुएशन ही कैन विद द परमिशन ऑफ कोर्ट फाइल द कंप्लेंट. मान लीजिए किसी फ्रेंड के घर में, देन इन दैट सिचुएशन दैट फ्रेंड कैन फाइल द कंप्लेंट विद द परमिशन ऑफ कोर्ट इन द एब्सेंस ऑफ द हस्बैंड. तो जिसके पास भी उसकी वाइफ रहती है जिसको उसने ऑथराइज कर रखा है, दैट पर्सन कैन ऑल्सो फाइल द कंप्लेंट. क्लॉज 3, व्हेन इन एनी केस फॉलिंग under clause A of the proviso of subsection 1, the complaint is sought to be made on behalf of person under the age of 18 years or of a lunatic by a person who has not been appointed or declared by a competent authority to be the guardian of the person of the minor or lunatic, and the court is satisfied that there is a guardian so appointed or declared, the court shall, before granting the application for leave, cause notice to be given to such guardian and give him a reasonable opportunity of being heard. So basically यहाँ पे पॉइंट ये है कि जो lunatic और minor उसका एक lawfully appointed guardian है and some other person wants to file the complaint on behalf of the lunatic or minor. So in that case the court will notice the lawfully appointed guardian, and the lawfully appointed guardian, if he opposes, then this person will not allowed to file the complaint. फिर से पढ़ लेते हैं इसको. When in any case falling under clause A. Clause A क्या है? Any person lunatic under the age of 18, all that, sickness, infirmity, etc. In that, who can file the complaint? They are simply saying that some other person with the leave of court. That some other person may be the guardian and some other person may be anyone else. So that some other person may be with the leave of the court may file the complaint. When in any case falling under clause A of the proviso of subsection 1, the complaint is sought to be made on behalf of a person under the age of 18 years or a lunatic by a person who has not been appointed or declared by a competent authority to be a guardian of the person. Means some person wants to file the complaint but he is not a guardian. मान लीजिए एक माइनर के लिए ये फाइल करना चाहता है, ये wants to file a complaint for minor M, लेकिन ए एम का गार्जियन नहीं है, लीगली अपॉइंटेड. अब इसने एप्लीकेशन डाला कोर्ट में that I want to file a complaint on behalf of M. The court finds that a G who is a legally appointed guardian for M. Okay. So in that case, what shall the court do? Before allowing A to file the complaint, court will give notice to G, and if G has any objection, then the court will not allow A to file complaint. अब हो सकता है G will file the complaint और ऑब्जेक्शन के बाद हो सकता है द कोर्ट विल अलाउ, so there may be chance that even after the objection of G, the court may allow to file the complaint by A. Because here it is clearly written the court shall before granting the application. So it is mandatory to for granting the application for leave, but it is nowhere written that court shall not allow if the objection is there. So court may or may not allow even after the objection. अगर ऑब्जेक्शन करता है तो कोर्ट डिसअलाउ भी कर सकती है कंप्लेंट बाय ए, और even court may allow. So this clause 4 related to commanding officer. All that armed forces are related है. The authorization referred to in clause B, the proviso of 2 subsection 1 shall be in writing. Authorization referred to in clause B जो armed forces वगैरह से related, proviso of subsection 1 shall be in writing, writing होना चाहिए, shall be signed or otherwise attested by the husband, साइन होना चाहिए attested by husband, shall contain a statement to the effect that he has been informed of the allegations upon which the complaint is to be founded. जिस पे कंप्लेंट फाइंड की गई है उस एलिगेशंस के बारे में उसका इन्फॉर्म कर दिया गया. shall be countersigned by his कमांडिंग ऑफिसर, और उसके कमांडिंग ऑफिसर द्वारा काउंटरसाइंड होना चाहिए. एंड shall be accompanied by a certificate signed by that officer to the effect that leave of the absence of the for the purpose of making a complaint in person cannot for the time being be granted to the husband. और सर्टिफिकेट भी उसके साथ, साइंड सर्टिफिकेट भी होना चाहिए ऑफिसर का कि उसको इस पर्पज के लिए लीव ग्रांट नहीं की जाएगी जा रही है, कंप्लेंट फाइल करने के लिए लीव नहीं दी जा रही है. सो जो सर्टिफिकेट होगा और ये साइंड डॉक्यूमेंट होगा ये दैट विल बी प्रेजेंट बिफोर द कोर्ट, और उसके प्रेजेंट होने पर जब अदर पर्सन फाइल कर सकता है क्या, कंप्लेंट. Any document purporting to be such an authorization and complying with the provisions of section 4, and any document purporting to be a certificate required by subsection shall, unless the contrary is proved, be presumed to be genuine. और जब तक contrary prove नहीं किया जाएगा ये presume किया जाएगा that those certificate or document that are produced in clause 4 are genuine and shall be received as in evidence, और वो evidence के तौर पे लिया जाएगा. सो दिस सेक्शन में क्लॉज 1 से लेके 198 में क्लॉज 1 से लेके क्लॉज 5 तक इट इज रिलेटेड टू अडल्ट्री, बाइगमी एक्सेट्रा. बट व्हेन वी मूव टू क्लॉज 6 इट इज रिलेटेड टू 376 ऑफ आईपीसी. और जबकि क्लॉज 1 से 5 तक ऑफेंस दीज आर रिलेटेड टू ऑफेंसेस अगेंस्ट मैरिज, ऑफेंस रिलेटेड टू मैरिज. बट क्लॉज 6 इज रिलेटेड टू अनदर ऑफेंस दैट इज 376. No court shall take cognizance of an offence under section 376 of IPC where such offence consists of sexual intercourse by a man with his own wife, the wife being under 18 years of age, if more than 1 year has elapsed from the date of the commission of offence. Now suppose H is married to W. Here H is married to W, and suppose here somewhere here there is sexual intercourse between the husband and wife, and here they are saying wife is less than 18 years. Then in that case what they are suggesting is that it will amount to rape, and therefore what they are saying is जिस दिन ये एक्ट हुआ, सेक्सुअल एक्ट हुआ है, उस दिन से 1 ईयर यहाँ पे होता है. उस दिन से 1 साल के अंदर अगर कंप्लेंट फाइल होता है, मीन्स प्रोसीडिंग्स हुए जिस दिन सेक्सुअल एक्ट हुआ है 18 ईयर्स से नीचे की है वाइफ, और उससे 1 साल के अंदर अगर प्रोसीडिंग्स हुए तब तक कोर्ट कॉग्निजेंस लेगा, अदरवाइज नॉट. नो कोर्ट शैल टेक कॉग्निजेंस ऑफ एन ऑफेंस अंडर सेक्शन 376 ऑफ आईपीसी वेयर सच ऑफेंस कंसिस्ट ऑफ ए सेक्सुअल इंटरकोर्स बाय ए मैन with his own wife, the wife being under 18 years of age, if more than 1 year has elapsed from date of the commission of the offense. Now suppose here somewhere the sexual act was done and 1 year is elapsed here, and now somewhere here the court want to take the cognizance. Will that be allowed? Will the court take cognizance? अब ये जो एज लिमिट है ये 18 ईयर्स है जो सीआरपीसी में. अर्लियर जो आईपीसी में था हस्बैंड वाइफ के लिए दैट इज 15 ईयर्स. बट अब तो अमेंडमेंट 2018 के अमेंडमेंट के बाद वो 18 ईयर्स हो गया है. बट what was the situation earlier? Let's see it. Why it is important to see? Because in essay writing other things और interview वगैरह में अगर by chance इस तरीके क्वेश्चन आ जाएं, then we should know what was the earlier situation and what is the present situation, and what are the conditions, and what are the measures that are taken in accordance with the law for the safety of the woman. Otherwise आंसर राइटिंग में तो टू द पॉइंट स्ट्रेटली लिखना व्हाट इज द लॉ इन प्रेजेंट सिचुएशन, बट इट विल हेल्प यू इन इंटरव्यू और essay writing all that. So earlier the husband और wife के बीच में will it amount to rape? It will amount to rape, but earlier in IPC the age should not be less than 15 years. तो 15 years की एज लिमिट थी. अब फिर उसके बाद प्रपोजल आया था पार्लियामेंट में इसको बढ़ाने के लिए, फिर कुछ समय तक पेंडिंग में रहा. नॉर्मल केसेस में जो आईपीसी में एज लिमिट थी दैट इज 18 years. So if earlier H has intercourse with W and W is less than 18 years, they are not husband and wife. In this example, they are not husband wife. Then per se it will amount to rape, even if W has consented. Earlier इससे पहले भी क्या था कि if W is any lady and any person does sexual act with her and she is below 16 years, 16 साल से नीचे है, with consent or without consent, then it will amount to rape. But now after 2013, after the Nirvaya case, in the 2013 amendment, they increased this age to 18 years. Means any man enter into sexual act to any woman if she is less than 18 years. Before that, before 2013, it is 16 years. Now it is 18 years after 2013. That will per se amount to rape even if she has consented. But at that time they also writing that sexual intercourse between the husband and wife will not amount to rape unless the wife is less than 15 years. तो 15 साल तक की अगर 15 साल से ऊपर की वाइफ है या 15 साल से ऊपर की वाइफ है तो इट विल नॉट अमाउंट टू रेप. So IPC में they were saying that between husband and wife it will not amount to rape unless the wife is below 15 years. But CRPC में उन्होंने उस टाइम भी 18 साल डाल रखा था. तो CRPC में तो उन्होंने लिखा था कि 18 साल से अगर कम की वाइफ है then it will amount to rape. But IPC में 18 साल नहीं है, it was less than 15 years. For this, the parliament sent a proposal to increase this age. But because there was a trend of child marriages in India, but the society was not as developed, and there are continuous going on that act of child marriages, and the awareness is too less, and literacy rate is less. There is more illiteracy in the rural areas. So अगर 18 साल उस टाइम अगर कर दी जाती तो then that every husband would go to jail अगर उसको बढ़ाकर 18 साल कर दी जाती. So as a matter of policy पार्लियामेंट ने उसको 15 साल को बढ़ाकर 18 साल नहीं किया. बट जो CRPC में था वो हमारा 18 साल था, IPC में 15 साल था. And which would we follow at that time? So which we would follow the substantive law at that time, and we would follow the IPC until the IPC is amended and it would increase to the age of 18. Till then, even though they were writing it is less than 18, we have to read it. It is less than 15 in the matter of husband wife, because CRPC के amendment के साथ corresponding amendment IPC में नहीं किया था उस टाइम. So IPC prevail कर रही थी. बट लेटर ऑन एक केस आया, राइट इट डाउन, मैंने लिखा नहीं है इधर कहीं, इसमें लिख लेना. इंडिपेंडेंट INDEPENDENT इंडिपेंडेंट थॉट THOUGHT वर्सेस यूनियन ऑफ इंडिया UNIONOF यूनियन ऑफ इंडिया INDIA. इंडिपेंडेंट थॉट वर्सेस यूनियन ऑफ इंडिया. The judgment came on 11th October 2017. Author was Justice M.B. Lokar and bench is D. Gupta. In this, they changed the age under section 375 exception 2 from 15 to 18 years. 15 से जो वाइफ की एज 18 साल कर दी गई इसमें in IPC. So earlier it was studied that in IPC under section 375 exception 2 it is clearly provided that if the wife is less than 15 years then the sexual intercourse between husband and with wife will not amount to rape. The age of wife was still 15 years before this judgment of 2017 and by amendment it was not been raised. Whereas in CRPC 198 clause 6 it was less than 18, the IPC being the substantive law will prevail and until an amendment is made, which is done by the overruled by this judgment, Independent Thought versus Union of India, pronounced on 11th October 2017 came. Whereas in CRPC it was less than 18, the IPC being substantive law will prevail and until an amendment is made in IPC, the word under 18 years in CRPC shall be read as under 15 years. So before this judgment, Independent Thought versus Union of India, we usually read to these two sections as harmony of CRPC and IPC. But now there is a change in the IPC and now this 15 year is read as 18 years only. So in IPC also the age is between the means when the sexual act is done with the wife below the 18 years then it would amount to rape only. Now clause 7, the provision of this section apply to the amendment of or attempt to commit of an offense as they apply to the offense. मीन्स जितने भी ऑफेंसेस पे ये सेक्शन लागू होगा उसके अबैटमेंट और अटेम्प्ट पे भी ये सेक्शन लागू होगा. So that's it for this lecture and for this section also. We will continue it with the 198A in the next lecture. Thank you for watching this lecture.